Welcome to the Customary Land Podcast. I'm your host, Spike Boydell. In this episode, I want to reflect on something that may sound technical at first, but which in truth goes much deeper than legal drafting. Fiji is currently reviewing the Mining Act of 1965 and the Quarries Act of 1939. At one level, that sounds like a matter for lawyers, administrators, government ministries, and perhaps those directly involved in the extractive sector. But beneath the surface sits a much larger question. What happens when a legal system built for extraction encounters a living customary system built around stewardship, relationship, and continuity across generations? And perhaps more importantly, what must be in place before development on customary land can be treated as legitimate at all? That, to my mind, is the real issue. The laws now under review come from another era. They were shaped in a colonial frame, and like many such laws, they carry assumptions that were never really designed for customary societies. They assume that minerals belong to the state, that access can be licensed administratively, and that those affected on the ground are largely to be dealt with through notice, surface compensation, and rent. In other words, they begin from the assumption that extraction is the norm and that the task of the law is to organise how it proceeds. But in customary settings, that is not where the question begins. Customary land is not simply a surface platform sitting above mineral wealth. It's not merely the site on which a project happens to land. It's relational. It carries belonging, memory, authority, use, obligation, and sacred significance. It is held not only in the present tense, but also across time. It binds those who came before, those who are here now, and those yet to come. And if that's so, then the central question cannot simply be, what is the compensation figure? The deeper question must be, what must be recognised, protected, governed, before compensation is even discussed? That's why this review matters. It matters because Fiji now has an opportunity not to simply modernise old laws, but to think more deeply about the foundations on which extractive development is permitted to proceed. Let me say clearly at the outset, this is not an anti-development argument. I'm not saying that mining should never occur. Nor am I saying that quarrying, extraction, or economic use of resources is somehow illegitimate by definition. Fiji, like other Pacific Island countries, like most countries, needs development. Communities need opportunity. The state needs revenue. Infrastructure, employment, and economic activity all matter. So the issue is not whether development should occur. The issue is whether development is structured in a way that strengthens stewardship rather than quietly weakening it. That is a different question altogether. One of the reasons this matters so much is that mining and quarrying are never simply about the moment of entry. They're about time. They're about duration, review, future value, risk, restoration, and who remains responsible when the first enthusiasm of a project has long faded. They're about who carries the burden of disturbance, who receives the benefit, who has voice, who has standing, and what happens when an arrangement made today quietly narrows the options for tomorrow. That is why one-off settlement logic is often too thin. A payment may address some material impacts, it may respond to some immediate damage, but it cannot, by itself, resolve the larger questions of legitimacy, participation, continuity, and responsibility. And the same is true of royalties. Fiji now has the Fair Share of Mineral Royalties Act of 2018, and that clearly matters. But even then, deeper questions remain. Because a royalty split, however neat it may appear on paper, does not answer the underlying issue of how value is being measured, how risk is being allocated, whether the basis of calculation is fair in the customary contexts, and whether the distribution method reflects customary realities, or whether royalty sharing is being mistaken for the whole answer, when the truth is it's only part of a much wider architecture. That wider architecture is what I think Fiji now has the opportunity to see more clearly, given that they're reviewing their legislation at present. Over many years, my colleague Alai Bayer and I have worked on these questions in different forms. In relation to Ngoli compensation, we found ourselves confronting the inadequacy of one-off payments tied narrowly to resource inventory. In work around the commercial use of marine areas, we found again that the real issue was not simply what compensation should be paid, but what had to be in place before development should be regarded as legitimate and enduring. And in mining contexts, we also explored option pricing approaches as a way of thinking more seriously about the value of undeveloped mineral opportunity on customary land. That may sound rather technical, but the underlying concern was very simple. Why is it that customary landowners are so often compensated for loss of access, disturbance, inconvenience, or surface impact, while the larger upside associated with future mineral opportunity is largely captured elsewhere? That earlier options work, the options pricing work, was never the final answer, but it did make something clear. Time matters. Duration matters. Review matters. The ability to revisit assumptions matters. And if a legal system fixes access, value, and participation too early, and for too long, then very large amounts of value can quietly move away from customary owners and communities before the real shape of a project is fully known. That remains a live issue, not just in Fiji, across the Pacific and in any location where there is resource development and extraction on customary tribal or indigenous land. More recently, we've been trying to hold these concerns together through what we now call SUITU. SUITU is a vernacular Fijian word, but we use it not as a compensation framework, not as a formula, not as a slogan, and it's certainly not an argument against development. It's better understood as a governance integrity spine. A way of asking what must be in place before development on customary land or in customary marine areas is treated as legitimate. At the simplest level, SUITU asks us to hold together 5 things that are too often torn apart. Stewardship, use rights, intangible values, tenure security, and the unifying strength that arises when these are not treated separately. Sometimes I reduce that to a single line. Legitimacy before licensing, responsibility before compensation, and continuity beyond one-off settlement. To me, that's the heart of the matter. Because if valuation comes first, or if royalties come first, or access arrangements come first, before legitimacy has been properly held, then procedure begins to replace authority. Payment begins to replace participation. And a law designed for extraction begins quietly, but powerfully, to shape customary reality without ever openly acknowledging what it's doing. That's why this review matters. It's not simply about which clauses should be updated. It's about the order in which questions are asked. Do we begin with the assumption that mining should proceed and then ask how to compensate? Or do we begin by asking whether the conditions of legitimacy have been properly established in the first place? There's another reason why this moment matters. Fiji is also moving in a wider legislative direction on Indigenous rights. The Rights of Indigenous Peoples Bill 2025 is now before Parliament. And you'll recall from an earlier episode in this podcast series that the previous government in Fiji hadn't been a signatory to the United Nations Declaration on the Rights of Indigenous People. There was a whole episode on those rights. But the important thing is, it's currently before Parliament. And that's important because it signals that Indigenous rights are no longer left at the level of moral aspiration alone. They're increasingly entering the legislative architecture itself. And if that's so, then the review of mining and quarrying law cannot be treated as though it sits in a separate universe. Particularly important here is the question of free, prior and informed consent, FPIC. Free, prior and informed consent is sometimes spoken of rather casually, almost as though mentioning it is enough. But if it means anything at all, it means moving beyond consultation as a procedural event. It means that materially affected customary owners must be engaged early, meaningfully, and on the basis of adequate information before licenses, access arrangements, or major project settings are effectively settled. Not after the framework is already in place. Not after the real architecture has already been shaped. And certainly not in a way that treats customary communities as merely one stakeholder among many, rather than as rights-bearing custodians whose relationship to land and resources is of a different order or magnitude altogether. That distinction matters, and I suspect it will matter more and more as Fiji and other Pacific Island countries continue to revisit questions of resource governance and extraction. Now, some may say, why not simply look overseas and borrow what appears to work? And yes, comparison can be useful, but it must be approached carefully. If we look at Australia, for example, Canada, New Zealand, and Papua New Guinea, they may offer partial lessons, but I don't think any of them provides a wholly satisfactory model if the real benchmark is customary legitimacy, enduring stewardship, meaningful participation in value, and long horizon responsibility. Australia remains heavily procedural and compensatory. And yes, elsewhere in this podcast series, you'll find discussions on the Griffiths or Timber Creek case, which made some acknowledgement of customary or special Indigenous value. And then more recently, in February 2026, there's the Davey case, and I'll devote a subsequent podcast episode to discussing why that's made some strides but remains very, very short of what it could do when we compare it to our SUITU pillars that we've discussed above. Canada has developed consultation and agreement making further, but still very much within a Crown-centred system, like Australia's system. New Zealand appears stronger on engagement with the Crown Minerals framework than on fundamentally reshaping underlying authority. And Papua New Guinea, while regionally relevant and important, often serves as much as a warning as an exemplar. So the lesson is not that Fiji should copy someone else. The lesson is that, given the opportunity to review its mining and quarrying legislation, Fiji has the opportunity to do better. And that matters all the more when comparative exercises are externally supported or funded, because comparison can easily drift towards investor-facing models, administrative familiarity, and procedural compliance, while the deeper customary governance questions remain under-articulated. This is where Fiji could become genuinely important, not because there's a perfect model waiting to be announced, but because Fiji has the opportunity to take a more coherent path. A path where compensation is not confused with legitimacy. A path in which royalty sharing is not mistaken for justice. A path in which consultation is not allowed to substitute for authority. And a path in which development is not understood not as a transaction that closes a file, but as something that must proceed, where it proceeds at all, under enduring responsibility. And we should not forget the Quarries Act of 1939. Mining attracts the larger conceptual discussion, but quarrying often affects customary communities more immediately, more visibly, and more physically on the ground, with dust, noise, access, surface disruption, environmental nuisance, local tensions, and so on. If Fiji reforms the Mining Act but leaves the Quarries Act as a weak side regime, with inadequate attention to customary land access, community impact, environmental responsibility, and fair surface rights arrangements, then a great deal of practical harm may simply continue through another legal door. So this review really needs to hold both pieces together, the larger and the smaller, the spectacular and the everyday, the mineral project and the quarry pit, the law and the lived effect. To my mind, Fiji now stands at an important crossroads. It can update old statutes while leaving the deeper architecture largely untouched, or it can use this moment to ask a harder but more valuable question. What would extractive law look like if it began not with administrative convenience, but with legitimacy, stewardship, meaningful participation, and long horizon responsibility? That's not a simple question, but it's the right one. And if Fiji is willing to hold it properly, it may end up doing something more interesting than merely catching up with comparative practice. It may begin to show a more coherent path, not only for Fiji, but perhaps for customary peoples elsewhere who continue to live with extractive systems built in very different worlds. If you'd like a copy of our full submission to the Fiji Law Reform Commission, or if you'd like to know more about SUITU and the forthcoming SUITU Mastery course, please email contact@customarylandsolutions.com. You'll find details in the notes for this episode. Thank you for listening. I hope this has been thoughtful and maybe thought-provoking. Until the next episode, stay safe, stay well.